first-degree felony offense of aggravated robbery, and that's from accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. For Jaden Worlds. And Mr. Parker, will your client waive the formal reading of the indictments and the motions in each case? Mr. Worlds, in cause number 26, DCCR 0361, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from January 21st of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then in cause number 26, DCCR 0415.
Right away, you can hear how routine this sounds, but don't let the calm courtroom tone fool you. Aggravated assault with a deadly weapon in Texas is no lightweight charge. The judge is carefully building a record here, making sure every plea is entered voluntarily, so there's almost no room for appeal later. And notice how short the defendant's answers are? That usually means the deal has already been negotiated behind scenes. The courtroom drama happened long before the cameras rolled.
Mini button. You're charged with a first-degree felony offense of aggravated robbery, and that's from January 27th of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In each of these cases, those two cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each of those cases. It's admitted in each case. Is there any evidence that Mr. Worlds is not competent?
No, Your Honor.
All right, sir. In cause number 26, DCCR 0361, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences.
20 years, just like that. And here's what really hits hard: the deadly weapon finding. That's not just courtroom wording. In Texas, that can seriously affect parole eligibility and future restrictions. So even though the sentence sounds straightforward, the long-term consequences are way heavier than most viewers realize. Imagine hearing the words 20 years twice in less than a minute. That's the kind of moment that changes an entire life trajectory instantly.
Consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding in that case of a deadly weapon. In cause number 26, DCCR 0415, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm also making an affirmative finding in that case of a deadly weapon. Now, in cause number 24, DCCR 1721, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation October 8th of 2024 for the state jail felony offense of unauthorized use of a motor vehicle, and that was a 5-year deferred probation. Is that correct? And then in cause number 24, DCCR 1420, we'll also have a motion to revoke your unadjudicated probation. This shows you were placed on probation October 8th of 2024 for evading arrest or detention with a motor vehicle, a third-degree felony. That was also a 5-year deferred probation. Is that also correct? Each of these cases allege that you have violated your probations. Count 1 in each case alleges that you committed that new offense of aggravated assault with a deadly weapon January 21st of 2026, the one that we just went through. Is that true or not true?
True. Judge, to save time, with the plead to count 5 and count 7 in both of those motions, and I'll be mad at the rest if it's.
Watch how fast this hearing shifts gears. The judge moved from sentencing on the new crime straight into probation revocation territory. This is where deferred probation becomes incredibly dangerous for defendants. A lot of people think probation means the case is behind them, but legally, it's more like the sentence is waiting in the shadows. The second new violent charges enter the picture, that old agreement can explode back to life. Do you think most people on probation truly understand how fragile those deals are?
Are different. I'm not sure if that matters.
But if those are the same counts,
There's not a
same allegations.
there's not a count 7 in 1721.
1420, there's a count 7.
Correct.
Count 5 in the other one. It's the same as count 7.
So 5 in one case, 7 in the other.
Yes, Judge.
So in cause number 24 DCCR 1721, it also alleges in count 5 that you possessed and used a firearm, namely a handgun, to fire shots at 2 people on January 21st of 2026. And is that true or not true? And then in cause number 24 DCCR 1420, count 7 in that case also alleges that same violation of firing the handgun. Is that true or not true? All right. So did you enter your pleas of true to counts 1 and 7 in 1420 and 1 and 5 in 1721 freely and voluntarily?
Yes.
And did you plead true to those?
And there it is, the word true. That single answer may have been the most expensive word spoken in this entire hearing. By admitting those violations, the defense likely avoided a contested revocation hearing, but also removed almost every remaining shield against punishment. Notice the judge doesn't need dramatic speeches or emotional reactions here. The paperwork, admissions, and prior agreements are doing all the heavy lifting.
Because they're actually true. I have also here on the tablet some documents in those 2 cases that have your signature on them that the state's marked as Exhibit 1. Did you also go over these with Mr. Parker? And do you understand them as well? And you also understand if I follow these agreements, you'll be waiving or giving up any right to appeal. State tenders number 1 in each of those cases.
Motion.
It's admitted. All right, Mr. Worlds, in cause number 24, DCCR 17.
And this is the moment the domino effect really kicks in. Once those new felony charges were admitted, the old probation cases basically collapsed instantly. In Texas, catching a new violent charge while on deferred probation is almost game over. The judge isn't just sentencing him for the new crimes anymore. Now every past deal with the court is back on the table. One decision just multiplied the consequences faster.
1721. Find that you entered those pleas to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1. Hold on, I just pulled the wrong one up. I looked at the wrong thing. What's the agreement on?
2 years TDC and 2 years state jail.
Gotcha. So in cause number 24, DCCR 1420, also find that you entered your pleas of true freely and voluntarily. Find counts 1 and 7 true. Find sufficient evidence at this time to find you guilty, and find you guilty of evading arrest.
Now, there's one detail viewers might miss. The judge ordered all 4 cases to run concurrently. That means the sentences run at the same time instead of stacking one after another. If these had been consecutive sentences, the total time could have become absolutely devastating. So while 20 years is already massive, this ruling actually avoided an even harsher outcome. It's one of those courtroom moments where the damage is severe, but still could have been worse.
Detention with a motor vehicle, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. In all of these cases, I'm going to hand you the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Here you go. Hey.
And just like that, it's over. No yelling, no dramatic outburst. Just a quiet ending to a chain reaction that started long before today. The judge even finishes with good luck, which almost feels surreal after handing down decade behind bars. That's the unsettling thing about real courtroom hearings. Life-changing consequences are often delivered in the calmest voices imaginable. 1 probation violation, multiple violent charges, and every prior break from the court vanished in minutes.
All right. Thanks, Judge. See y'all later.
This is the moment the domino effect really kicks in. Once those new felony charges were admitted, the old probation cases basically collapsed instantly in Texas, catching a new violent charge while on deferred probation is almost game over. The judge isn't just sentencing him for the new crimes anymore. Now every past deal with the court is back on the table. One decision just multiplied the consequences fast.